now in session.
Thank you. Please go ahead and take your seats. All right, we are calling the matter of Gabriel. Could you pronounce your last name for me, sir?
It is Gigena.
Thank you. Gabriel Gigena versus Finch, case C104947. Mr. Gigena is appearing representing himself. He's on Zoom today. Sir, can you see and hear me okay?
Yes, I can.
Thank you. And could I get the appearance from respondents? Thank you very much. Mr. Gigena, you do have 15 minutes to present your argument to us, but if you would like...
Yes. I couldn't hear the respondent.
Mr. Hobson is here, and when he begins his argument, he'll move into the center at a podium with a microphone, and you should be able to see him on Zoom.
Understood.
Okay. Sir, you have 15 minutes to present your argument to us today, but you can reserve time after Mr. Hobson's argument if you'd like to. Would you like to reserve any of that 15 minutes for rebuttal argument?
May I reserve 5 minutes for rebuttal?
Sure. You will note when you start your argument, there's a timer that will pop up on the screen and begin counting down from 15 minutes. Would you like me to remind you when you get below 5 minutes, or do you want to keep track of that yourself?
I'll try to keep track of it myself.
All right. You may begin anytime, sir.
Okay. First off, it's a great and revered honor to be before this prestigious panel. Thank you. To dive right in and to the reasons why reversal is warranted, I'm going to deal with first the structural error of the court failing to provide a verbatim record. The cases that are relevant to that are the Jameson case that I discussed in the brief, and then also there's a case that's teed up on in the Supreme Court, Family Violence Appellate Project versus the Superior Court, where it's a constitutional right to have a verbatim record.
Mr. Gigena, let me interrupt for 1 minute. This is Justice Earl. I don't see where you've raised the issue of the lack of a court reporter or a reporter's transcript in your brief with us. Can you point that out to me?
That is on page 22 of the reply brief.
And did you raise this with the trial court when you were at the trial court?
I had requested a court reporter, and according to the rule of court 2.956 C2C, if the proceeding is continued, that so is the request. And then because they also failed to provide a electronic recording, I provided it with a link in the opening brief to preserve that right, and that is under rule 2.952J, and there was no dispute on whether or not we could utilize that record, and that way there's no reason to proceed on just the judgment rule because there is a record.
Thank you.
And then, so there's more, though there are two viable paths to costs on appeal for the attorney fees. They're on page 7 of the appellate court's order. It was in the posture of an injunction, and being in the posture of an injunction, there is well-established case law that counsel fees are permissible costs. The seminal case is Lambert versus Haskell, 1889, 80 Cal 611, and that's at 625, where damages for wrongfully issued injunction include reasonable counsel fees incurred in dissolving it. And then Russell versus United Pacific Insurance Company, 1963, 214 Cal App 2nd, 78, and that's at 87 and through 89. And that's a foundational case establishing that reasonable counsel fees incurred in successful procuring a final decision dissolving an injunction are recoverable as damages. And then Alba Rubber Company versus Sequist, 1991, 235 Cal App 3rd, 1, and that's at 11, 14, and 16, confirmed that the fees and expenses necessary to dissolve an improperly granted injunction are compensable damages on the injunction undertaking, even prosecuting an appeal. Issuance of the undertaking for the injunction is statutorily mandated and cannot be waived by the respondent or the restrained party's silence. And that's California Code of Civil Procedure, Section 529, and requires that the amount of the undertaking be sufficient to pay to the party enjoined such damages as the party may sustain by reason of the injunction, if the court finally decides that the applicant was not entitled to the injunction. The sole limit imposed by the statute is that the harm must be proximately caused by the wrongful issued injunction. And lastly, the vexatious litigant code for the definitions under the security that was issued for me to be able to proceed included attorney fees, and that was not limited to taxable costs. And then Mr. Hobson did not dispute the costs personally, as he is a named defendant, and waived taxing of costs against him personally. And lastly, because of the respondent's frivolous motion and contumacious conduct to make this court's order surplusage warrants punitive and exemplary damages. And I invite the court to any questions it may have had concerning the opening and reply brief.
I just had one question. This is Justice Earligan about your argument about attorney's fees. In your briefing, you point to Code of Civil Procedure Section 425.16 and Civil Code Sections 3281 and 333. Is that the law that you're relying on to support your argument that you're entitled to attorney's fees?
Yes, that was the law that I was relying on during the proceedings. But Mr. Hobson, being an attorney, he has a duty to make sure that the proper law is brought before the court. And I just discovered the injunction law just on Friday.
But my reading of the record of what happened in the trial court is that you were never represented by an attorney, so why would it be, why would an award of attorney's fees now be appropriate if you didn't incur any costs associated with that?
It was for procuring the power of attorney because I was incarcerated and I needed assistance in filing documents, and I actually had to write my brief from inside the cell. I beat those charges. They were dismissed for lack of proof, lack of evidence. That case actually correlates with the misconduct between the two counties that I've been having to deal with in civil suits. But that's the reason why it's an approximate cause. It was necessary to prosecute the appeal and have that decision overturned. It's been multiple abuses from the same judge. If you look at case C100546, that was up on a appeal in the appellate division of Amador, but I had sought a petition for writ of mandamus in this court, and the lower court had moot the issue raised on appeal, counter to the precedents that was provided. And then on the same judge that was in the criminal case, he was sitting on the panel of that appeal. And then C104425, I had excuse me, the previous case, it wasn't, I was seeking further appeal, but on this case I was seeking the petition for writ of mandamus because the court was enforcing an oral agreement with my attorney, and where the attorney omitted the terms and added terms, and the bar rules and statute declare public policy explicitly prohibiting agreements not in writing. So that's why I sought the petition for writ of mandamus in this court. But Judge Day had sat on the appellate panel of that proceeding. In the prior case where she declared it moot, she was trying to declare me incompetent to stand trial because of me enforcing my American Indian tribal rights.
All right, well, I don't think that issue's before us yet.
Oh no, it was they were both denied, but I know in the 10th Circuit Court of Appeals, they have precedents to be able to look at related cases, and I don't know if that's the same with this court. It would take me, I'd have to research that.
All right, it doesn't look like we have any additional questions. Would you like to reserve the remainder of your time?
Yes, please.
Good afternoon, Justices. Kevin Hobson appearing for Respondent Rick Finch Body Shop, to address Mr. Gigena's specific points. The lack of a verbatim transcript, referring, I guess, to a court reporter, the local rules and the way that the motion to tax costs arose, the court issued a tentative decision, and by the local rules, which is included in the motion, appellant had until 4 o'clock the preceding day to object to the tentative decision. He did not object, and so there was nothing on calendar on the day he's requesting a court reporter, and so I didn't even appear because the decision had already been entered. As to attorney fees, there's just simply no statutory, there's no contractual basis They weren't awarded in this court's decision. On the next level, he never really had an attorney. Apparently, his argument is the power of attorney allows attorney fees. So, again, on the attorney fees, there's just simply no basis. On the costs, we admit that there are certain costs that are awarded to the appellant. Specifically, there was a mailing cost, and I'll refer, Mr. Gigena refers to categories, and in category 1, he refers to a $608.87 charge. We admit that $80.88, which he sets forth, constitutes mailing costs, which is a legitimate cost under the rules of court 8.278. The others, the remaining 600, is not explained as to what that is. He categorizes it as a production of evidence, which would be, in the right circumstances, a legitimate cost, but he doesn't indicate what the 600 is for, just merely production of evidence. The remaining cost, which we admit to, is $5 for the court reporter. That was her cost. The remaining costs constitute attorney fees, which I've addressed. The others, there's a category that consists of various charges. It's paper clips, toner, earbuds, plastic cups. I think gas is asked for. I'm not positive on that at some point, but I think the rules of court are very specific as to what he is entitled to. The one question is the filing fee for this court and the cost of the transcript by the trial court, and normally those are costs. And the question becomes, he cites a government code section that he didn't pay the cost, but the question becomes, does my client owe those costs?
Right. Your client has to pay the court the costs that are waived.
Pardon, Your Honor?
I think the way it works is that when costs are waived and the person whose costs are waived prevails, then the losing party pays the court the amount of the filing fee, for example, that was not paid because of the waiver, because the court is suffered by losing the filing fee, but because the person who paid it won, then they get it paid by you. So that's the way it's supposed to work. I'm not sure it does all the time.
Right, and I think my only concern or argument was that government code section, to me, it could be interpreted at the trial level if it's a cost at the trial level versus appeals. But I don't have a strong argument that if the court says my client owes money for filing.
The bottom line is it's not owed to the petitioner here, it's owed to the court.
Yes,
The
if
trial
it's
court
owed,
or the Court of Appeal.
yes, if it's owed definitely to the court. Yes.
Thank you.
So, if the court has any questions.
I just had one question. Mr. Gigena seems to interpret Rule 8.278, subsection D1, as providing for recovery of any costs that are reasonably necessary to conduct the litigation. Let me make sure I have that right. And I just wanted to know what your take on that was.
Right. When I looked at that particular rule, there's a specific list of categories that what are justifiable costs. That is not included. My interpretation of that language, and that is the language in the interest of justice, the appellate court can award costs. My interpretation of that is at the time of the decision, if the court believes there are certain costs that are outside the parameters listed specifically, the court has authority to consider those costs. I don't consider that language. To me, if that language was an all-inclusive sort of catch-all, it would have been listed in that same category where they go through filing fees, production of evidence. To me, it would have appeared during that list.
I'm sorry, I think it is within government Code of Civil Procedure 133.5. All right. Mr. Gigena, you have just over 3 minutes remaining.
Okay. Mr. Hobson is a little bit confused about some of the things that were on the receipt. They were definitely not charged in the memorandum of cost. They were specifically omitted, like the earbuds, because they were unrelated to the cost. As to the court fees, the judgment explicitly said if payable, and didn't specifically. That's an open-ended judgment. It should be strictly expressed that it must be paid. The government code says that it must be paid. It has to be paid before I am paid.
Do you agree with the conversation between Justice Roby and Mr. Hobson that if it is to be paid, it's to be paid to the court since your fees were waived?
Yes, it is. It is supposed to be paid to the court. It doesn't. I've never argued that it's supposed to be paid to me directly. Just that the judgment has to express it. As to the items that he is saying that aren't allowable, you did cite the code correctly for Rule 8.278D. 1 and E, where I believe the correct code is 8.278. They are misinterpreting what I was saying as copies should be liberally construed as a pro se litigant, as the cost for printing filings and service of documents, which also includes the reason for having a power of attorney to have to that was utilized as a delivery per se, and then for proof of service, those are expressly allowed. They don't have to be actually paid for, but it states under the rules of court and the CCP 1033.5 that these, when service is by other means, the recoverable cost is the amount to the public officer, which is the reason why I had submitted a copy of the fee schedule, which is $50 per service, and the reason. And that there were 10 services, so that's where those costs apply.
All right, thank you, Mr. Gigena.
I see my time has run out. I thank you. I thank this court for its time and consideration in this appeal.
Thank you. We will take the matter under submission. We'll take a brief recess to reconstitute our panel.